Her Majesty's Revenue and Customs.
My Lord. This case is about the scope of the revenue's discretion when taking someone out of gross payment status under the construction industry scheme. I will be addressing you on the statutory construction arguments and Miss Boyd on the proportionality and human rights aspects.
Keep your voice up and keep the
Yes.
microphones pointed in as
Okay.
the usher is placing them.
And subject to your preference otherwise, we intend to divide the time equally and speak for about an hour each. Is that better? I mean, can you hear properly?
Yes, but keep your voice up.
It is necessary first to talk about how this scheme works and what it is for.
But I think you probably need not spend too much time on that because it's fairly obvious, but what are the broad themes?
Broad themes are that since 1971, this requires some but not all subcontractors in the building industry to be paid subject to deduction of tax. Yeah. And that the courts have said that this was done to clamp down on tax evasion, in particular by small building outfits who had vanished without paying tax. There's authority for that in two cases, which talk about the purpose of the regime, Vicky Construction and Arnold and G-Con.
Sorry, say the case again.
Vicky Construction,
Yes.
which is at manuscript 467,
Right.
volume 1, tab 18.
Yeah.
And Arnold and G-Con, manuscript 696, volume 2, tab 27. The passage which is generally referred to as the Vicky one, if I might take you to that, which is manuscript 467.
I think manuscript is probably slightly out of date.
Page 467.
Either memory stick or else electronic, I suspect, is...
Okay, it's at memory stick 467.
Right.
First volume.
Yep. Have it.
And if I ask you to read 3 to 5 in that.
Sorry, asking us to read.
Paragraph 3 to 5.
Thank you very much.
Yes.
So there has always been the option for subcontractors to escape the deduction system and receive their fees in full, which for the reasons in Vicky is seen as an advantage.
Right.
And we would say that there's nothing exceptional about this gross payment status, or historically having a certificate of gross payment. It is one of the two main options available to subcontractors. You're either registered for gross payment or you're registered under deduction. Neither option was introduced before the other. They've always been the two and operated in tandem. And contrary to the revenues case, there isn't a realistic sense in which one is the default and the other the exception. While the Court of Appeal pointed out that the majority of subcontractors, around 90%, are registered under deduction, there are also turnover requirements to being under deduction, so we don't know actually what the proportion of eligible subcontractors who are registered under gross payment is. But in any event, 10% isn't an exceptional position. Sensibly, one could say that for the larger subcontractor, gross payment is what you would expect to have because you would expect to meet the conditions. You generally expect people to comply with their obligations. I would say that neither in Arnold nor in Vicky is there a suggestion, as the Revenue make. They make this in their case. Well, the suggestion they're making is that strict compliance per se is part of the purpose of the construction industry scheme as a whole. They say this in their case at 42, 58 and 72.
Let's just look at that.
Which page 106, that starts out in the core volume. 42, where they say that to prevent the incidence of tax evasion by ensuring strict compliance.
What's wrong with that?
They say that when you look at how it operates in the cases that they've drawn attention to for that, what the courts have said is that strict compliance is part of Parliament's intention in how the compliance test was laid out. It's not part of the general purpose of the regime as a whole. The point of the regime, I think it's been made quite clear, was to prevent people vanishing. It's not, in itself, imposed so that builders are held to a higher standard of timely payment than, for example, barristers. I mean, the revenue have an entire penalty regime for late payment to deal with that. And I would say that the requirements imposed on acquiring gross payment status, which are the form of your business, your turnover, and your compliance record, while they are what has been selected as the tests for gaining gross payment, maybe because it makes it easier, this signifies the contractors that the revenue find it easier to keep track of, or maybe just as a sort of a carrot, because it's known to be a desirable status. This isn't what the CIS is for, and I'd draw comparison there with the Supreme Court's decision in Whitter. If I might take you to that, which is the page number 933, Authorities Volume 3, tab 33.
Yes.
The passage I want to draw your attention to is paragraph 21.
Right, yes. Yes.
And I say that, as in that case, what you had was a general purpose of removing the financial benefits of crime, which, as drafted, included a very strict and wide regime which had deterrence advantages. But those deterrence advantages were not within the core of that general purpose, so the amelioration produced in Whitter by proportionality did not undermine the general purpose. Here, while the compliance test, which has been held by the courts to require strict compliance, and these, I'll give you the references where the courts have said this, but these are all cases about how they interpret what the historic minor and technical exemption to compliance test, and they said you interpret that exception in the context of a strict compliance threshold. That strict compliance test is not, it's just part, as with Whitter, it's part of how they carried out their machinery, but it's not the core purpose of the regime. And so we aren't asking that the compliance test be made more flexible. We admit that we failed the compliance test. What this case is about is what happens next. What will the revenue do once you fail the compliance test?
If the failures of compliance had occurred before the certificate was originally granted, and the certificate was refused on that ground, would hardship be relevant?
No, my lord.
Well, in that case, how do we apply the provision of section 66(1), which makes it a ground for revoking the certificate that if an application to register the person for gross payment were made at that time, the board would refuse. I mean, if hardship is not relevant to the original grant, and a ground on which you can revoke the grant is that you wouldn't give them a certificate now, it's a bit difficult, isn't it, to suggest that hardship can make a difference at either stage?
I would say that I disagree, my lord. In this case, because since 1971, there has always been a distinction that grant or refusal in the first place is mandatory, but removal is discretionary. So it is envisaged that there are cases where you would not meet the tests, but you keep your status.
In the sense that they're clearly entitled to refuse a certificate to somebody who has a bad payment record.
Yes, in fact they're required to refuse an additional one to somebody with a bad payment record. I would say is the interpretation of section 63. But they're not required to take it away. And a comparable situation where I said this isn't actually that surprising, which arises on the Road Traffic Offences Act. I think the ushers brought up a small file of the authorities that we and the Revenue have sought to add in, and this is the first tab of that file, which I've numbered as 58.
Is it to be followed by a memory stick?
It will be followed by a memory stick. I think it could both ours and the Revenues in one.
Yes, what are we looking at?
And we're looking at section 35,
Yes.
which is the last page of that first tab. Starts at the bottom on one side and flips over to the other.
Right.
And here you have the fact that the court, if somebody reaches a certain number of penalty points, the court must order him disqualified unless there are grounds for mitigating the normal consequences. And at 4, subsection 4b, it describes that you are not to take account of hardship unless it's exceptional hardship. And there's 2 points I'd like to draw from that. One is that it was assumed by the draftsman that without any clarification, mitigation of the penalty would include mitigation for hardship. But the other is that here we have the removal of a permission to drive. That permission is a matter of public safety. And the removal involves factors which do not go to the grant, because nobody can try to pass their driving test by saying, well, I'm going to plead exceptional hardship. I made 2 major faults, but I really, really need this car to get to work. So it's not that strange to say wider consequences are brought in when you're taking a privilege away from somebody. And in fact, the bringing wider consequences in would be seen to be one of the reasons for imposing a discretion. Because if there are no wider tests in, then they could have made the cancellation on the same terms as the grant, which is the Revenue shall remove it if it appears to them that any of these are satisfied. I did say earlier that the authorities that for strict compliance being a purpose are about the way you construe the compliance test itself, and references for those are Templeton and Transform Shop, which is page 692, volume 2, tab 26 at 14. This is about construing the minor and technical exception. And Arnold, manuscript 701, volume 2, tab 27 at 28.
Yes.
And I say that this is about what Parliament meant in the compliance test, rather than what the overarching purpose of the scheme is, which is to prevent building subcontractors from disappearing. Because these were all cases essentially about whether or not someone could be treated as meeting the compliance test.
Isn't it a bit curious, though, to have a precondition which is has to be complied with substantially, except for minor and technical defaults, without that having some relevance to the nature of the scheme? I mean, why have such a precondition unless you're concerned that this should, to check that this will be likely to continue if you grant this concession?
Well, I think that probably is part of the purpose of the compliance test. And similarly, but I'd say this is on the same level that deterrence was part of the purpose of the regime in Wire. It's a subsidiary purpose of part of the way it's been structured.
Yes, I see.
But it's not what the regime is for.
Well, the scheme of forfeiture of driving licenses is totally different, both in its purpose and in the way that it's set up. The removal of a license is basically not remedial so much as punitive. You can be completely satisfied that a person is a safe driver and nevertheless remove his license because, for example, he's driven without insurance or he has committed some breach of the law when riding a bicycle. I mean, it's purely punitive.
Well, I would say that this does have punitive elements, and I would also say that those breaches do go to what is viewed as being a safe driver. I think driving without insurance is an indication of what counts as a safe driver in this country. But, for example, the fact that if you have your gross payment status removed, you aren't allowed to apply for another year, is a device of a punitive aim.
Well, surely it's actually simply administrative in order to stop people from for the revenue from being deluged with automatic reapplications.
Well, there's nothing that stops you making automatic reapplications. You're simply refused in the first place. So you are put in a worse position than any other subcontractor under payment under deduction. And it is assumed by this, partly because your cancellation won't take effect for 90 days, but also because it's very unlikely that all your failures will be just before revocation. But there may well be a period in which you meet all the criteria in the last 12 months, but are prohibited from obtaining gross payment status, which of course is going to routinely be the case if you exercise your right to appeal.
Can you just help me on, I mean, it may not be relevant, but I'm intrigued by what's actually happening in this case. I mean, we're talking about defaults which happened in 2010 and 11, and according to the Court of Appeal, in July 2011, you got your tackle rather better in order. But here we are in 2018, so 7 years have gone by, in which you've been able to continue to operate under the old procedure. And do we assume that during that period you haven't had any further defaults, or what do we know about that?
My understanding is that our record has been is that certainly the problems that happened at the time ceased, but this isn't the point which I think.
No. I mean, it's just I'm trying to understand the practicalities, and if we were to uphold the decision of the courts below, then as from that moment you cease to be allowed to operate the system. Is that right?
Yes, that's how.
But in a year's time you can have another go.
Yes. And my instruction is that we are now compliant. So if it weren't for that year, that strict year out, we would.
And presumably, would the revenue have a discretion to say, well, yes, you did go wrong 7 years ago, but actually over the last 7 years you've been fine. So maybe we won't.
I don't believe they do have that discretion, my lord. If you look at the legislation, because we're prohibited from applying for 1 year.
No, I understand that. It does seem to be slightly weird in the circumstances of this case that we're talking about things that happened 7 years ago. But anyway, there we are. That's what we have to deal with. And is the legislation still the same?
In that respect, yes, my lord.
Okay.
There are some parts of the legislation which I would like to take you to. Actually, not for very long. The legislation we're arguing about is in the first volume at tab 7, starting on page 274. '57 just introduces what it's about. It obviously doesn't apply to all subcontractors or all contractors. Particularly the head contractor who has to make the deductions. It only applies if you've got a construction business or are one of another series of defined bodies, typically needing to have more than £1 million a year in construction operations.
There are references, you're either registered for gross payment or registered for payment under deduction. Are they exclusive of the whole terrain? In other words, there's no further possibility, you can't trade at all, or what?
There is a further possibility, which is that the revenue refuses to register you at all, which typically will only happen after some kind of deliberate or dishonest fault, in which case there is a higher rate of deduction imposed.
I see. So that's under some general provisions?
Well, it will be that the requirement to deduct section 61, and that, by reference to regulations, gives Whitter, in fact, the two levels of deduction.
Yes, I see.
The registered and the non-registered.
Yeah. Anyway, there are advantages in both forms of registration, but there are greater advantages in registration for gross payment.
Yes.
Right. Carry on.
And 60, which you will see, states that the requirement to deduct subject to exceptions if it's an employment, basically a taxable as employment income, or you have gross payment status. But while this defines the lack of deduction as an exception to the general requirement, the actual status, as defined in section 63, the two ways you're registered,
Yes.
as I said earlier, doesn't prioritise either form of registration. You just are registered for gross payment or you're registered for payment under deduction, depending on
Right.
what your application is and whether you meet the requirements. And you need to meet conditions that are set out in the schedule. The schedule is at page 284.
Which page?
284.
Wait.
And it's divided into three parts for individuals, firms and companies, with a supplementary part. And every applicant has to satisfy a business test, a turnover test and a compliance test. The business test is the same for everybody, which is that you carry on a business in the United Kingdom, including construction operations, or the furnishing of labour for construction, and that you use a bank account. Then there's the turnover test. I mean, we're dealing with the company one. Which is they have to have turnover of more than either £200,000 or £30,000 times the number of relevant persons, whichever is lower. There's a point.
The certificate could be revoked under section 66 if the turnover fell below the threshold after the certificate had been granted. Is that
Yes,
correct?
that would be a reason to revoke.
Yeah. I mean, that clearly wouldn't be punitive, would it?
Well, it would have.
It might inflict hardship, but
It might create hardship, but
yes,
that wouldn't be.
It would not be punitive in intention. It would simply be you'd no longer qualified.
Yes, my lord. There's one point I would make about the turnover test, which is that the revenue say that all these concessions are actually about compliance. They say this in their case at 47, manuscript 108, which I would ask you to look at.
But not quite. They say conduct of its tax affairs. Is that compliance? And yes. Anyway, what's your point?
My point is that I don't think their reasoning for saying the turnover test is also basically about compliance, which is set out in their footnote, works. Because they talk about the concern that your cash flow means that you hold on to deductions to pay your own bills rather than account them to the revenue. But that's something the contractor would be doing, not the subcontractor. The contractor is the one who makes the deductions and keeps the money until they give it to the revenue. And second, that kind of cash flow issue is about margin, not turnover. So I don't think there is any real basis to say that the turnover test is about compliance on any level. I think the turnover test is clearly the revenue have an interest in. It's easier for them to keep track of businesses that are of a certain size, but that's not about your tax conduct. So I don't think it's right to say that all of these are all of
But
these tests.
the turnover test applies to the subcontractor, your clients.
Yes.
And what the footnote says is that it's designed, you're the people who receive payment gross who have to account for tax to the revenue. The requirement of a substantial turnover is some sort of guarantee that you're likely to have sufficient cash flow to meet your tax obligations. So that makes sense, doesn't it?
Well, I think that actually, certainly partly because the turnover test threshold is so low, but also because it tells you nothing about the margins you're operating on,
Right.
which is actually your real problem with cash flow, and whether or not you are using your the sums on account of tax to support you.
Yeah.
But
Yeah, well,
also,
I see. I
there's
mean, I
nothing
think
wrong with doing that. That's what every business does.
there have been recent examples, perhaps, on one view, of substantial turnover, but nonetheless cash flow problems.
Yes, my lord.
All right, well,
And of course, the section that we're arguing about is section 66.
but the answer, so far as we look at Schedule 11, it is apparent that these are strict obligations, that there isn't much wriggle room. If you fail to comply, that justifies a refusal to register.
Yes, it does. And the compliance threshold in 12
Yeah.
is intended to be strict.
Yeah.
It's ameliorated in two ways. One, by the published list of tolerable failures, and secondly, by the protection for reasonable excuse.
Let's just give us the reference to those.
The references to those are subparagraphs 12.2 and 12.3.
Yes.
And these replaced the earlier version where there was, instead, the revenue had to make a judgment as to whether or not the failure was minor and technical, giving rise to no concern about future compliance. If they judged that, then you had complied. And so the discretion did not arise.
Yeah.
The list they've published is in the regulations, and it's at manuscript 323. This is tab 10.
Yes.
And you'll see there's a limited number of quite clearly defined defaults. The revenues suggest, in their case at 51, that things can be in this implicitly. I don't think that's how this list is supposed to work. It gives you a list of quite clear errors. And
Sorry, which page is the actual list on?
the actual list is on page 323.
Yeah.
323 to 4.
Yes. Right.
So some of the individual failings might come within 32 that there was no exemption because of the
Because of the number of...
because of the repetitive element.
Yes, my lord. I'll be saying that one of the problems, I say, with the revenues construction is it leaves the main function of their discretion as the creation of a further unpublished list of essentially the same kind of thing, which is failures of a certain level of frequency and a certain level of seriousness.
Sorry, where is that?
In my case or in my...
No, sorry, I didn't get your point. You say there's an unpublished list.
No, I'm saying that if the revenue are right,
Yes.
that the reason they have discretion
Yes, correct.
is, as they say, in fact...
Oh, I see. Sorry, I understand. Yeah.
Where they say that is, I think, at page 109.
Yes.
It's at paragraph 51 of their case, where they say there may be expectable circumstances in which a minor complaint's failure is not explicitly or implicitly, which is not addressed expressly or implicitly by Regulation 32. Or say, one, things aren't addressed implicitly by Regulation 32, it's a list of strict examples. And second, given that they have published the list of tolerable failures, if the point of the discretion can't be simply to have another range of the same kind of tolerable failure, but one which is simply not published.
The difficulty is there a difficulty with this argument that while you can make that point against the revenue, they can respond as against you that you're seeking to introduce a huge area of potential exception of an entirely unspecified nature outside anything which is express in the regulations.
Well, so this is not, I would say it's not actually that surprising. And the reason for this is, first, it's assumed by the structure of legislation that different things come into play on cancellation than on grant, because the tests are different in that cancellation is discretionary and grant is compulsory. So clearly the assumption of the legislation is that the revenue do have something new to think about that they wouldn't think about on grant.
Well, I mean, a possible alternative is, isn't it, that may is simply there because it would be pretty odd to find a provision which said shall or must, because in the nature of things, the revenue would be quite likely from time to time to overlook the position or fail to cancel a registration. You wouldn't want complaints by competitors or suggestions that this involves some sort of breach of duty. Is that a possibility?
Well, I'd say...
I mean, it just strikes one that would have read a bit odd if it had been absolute, but I mean, I think that's your case.
I mean, it's may, because a certificate may be absolutely open to revocation because all the statutory tests are passed, but the Inland Revenue may decide that in the particular circumstances, although there was no reasonable excuse, that no useful purpose would be served, or that for some reason the taxpayer can be expected to comply in future. All of these factors may enter into the decision. It's simply part of the mechanics of tax collection, and the revenue have a discretion because they have to fit all their decisions into the broader context of collecting the tax.
I'd say that if you look at section 66, I mean, this is the first answer to those points is that this can't be simply because they're not expected to keep a constant watch and revoke as soon as something goes wrong, because there are two, the power to revoke only arises when it appears to them
I see.
that things are broken. So nobody could turn to them and say, well, you should have revoked this 6 months ago. Why haven't you done that? It's only when it comes to their attention and they decide that the factors are met that they have the power.
I mean, can I ask you a related but different point? As I understand the agreed facts, it's always going to be a hardship for somebody who has a certificate to lose it, because it immediately makes him a much less attractive candidate for subcontracts. That's going to be true of pretty well everybody with a certificate under this scheme. So if your submission is right, it means that although had the revenue anticipated that this would happen, or if it had happened in the past, they would perfectly lawfully have refused a certificate. Once they've granted one, they're caught, because there's always going to be a hardship arising from its revocation. And that seems a distinctly odd result, which would make Section 66 inapplicable in a really rather high proportion of cases.
Well, all that's required is that they consider it, which is something which they are certainly able to do. If I take you to, for example, a much wider...
Well, the notion of having to consider it implies that if the hardship is made out, they ought to give effect to it. I mean, it's not, it can't be just a sort of arbitrary personal prejudice.
Well, I think the revenue do cope with factors of hardship in a more nuanced method. I mean, if I take you to volume 5, at tab 55, page 1968, this applies to penalties under the construction industry scheme. And there is, I mean, it's mentioned in our case, there's the general power to mitigate penalties, which the revenue have generally accepted, includes mitigation for absolute and exceptional hardship. It doesn't say that in the Act. And obviously everybody can always say that a penalty has a bad impact on them. That's what it's supposed to do. But the revenue do manage to cope with the idea that sometimes you might be able to draw attention to such exceptional hardship that the penalty should be reduced or waived. And they deal with this in quite a sensible fashion in their guidance here. They expect the taxpayer has to put the prima facie case to them that they're in an exceptional situation, that the damage done to them is far beyond what you would normally expect from the penalty, has to provide proper evidence.
Where's that?
On them.
You say that's in this...
That's in their guidance on the further mitigation under TMA 102. If you go to halfway down that, if the further grounds include genuine and absolute hardship.
Sorry, I'm not with you. Page?
1968, near the bottom.
Oh, I see. If the further grounds include genuine and absolute hardship.
You have to produce financial evidence in the whole stream of things, yes.
But where does it say exceptional?
Well, genuine and absolute is the phrase they use.
Yeah, but you said it has to be exceptional, going beyond what would be expected.
Well, that is, I think, what the revenue mean when they talk about genuine and absolute hardship. That obviously a penalty causes you hardship. That's what it's for.
Yes, I mean, and no doubt in this case,
yeah.
You would say it causes you genuine and absolute hardship, but it's no different from what one would expect from the operations of the scheme.
Well, what I'm drawing from this is that the revenue have shown in other fields of their activity, as for example they do in the confiscation and smuggling, that they are able to deal with the idea that a taxpayer may plead hardship, but the hardship is not bad enough to depart from their usual policy.
This is purely to do with penalties. It's nothing to do with the subject matter of this case. You're just relying on it.
I'm relying on it as an example that they're capable of dealing with this kind of question, and that the fact that hardship is relevant would not mean, as my lord was suggesting, that 66 would stop generally applying. it would still be on the subcontractor to say why their case fell outside the norm.
The analogy is only good, isn't it, if one accepts your submission that the Section 66 regime is basically penal.
Or partly penal.
And not remedial.
I would say if it's entirely remedial, it still has a damaging effect, and therefore the more basic point I make on this is that the revenue would be capable of applying Section 66 probably in 999 times out of 1,000 in exactly the same way they do now, while taking account of the fact that it is open to them to consider hardship, which is what they rejected in this case. They said that we cannot think about this. Whatever you say, we don't need even to look at it. It doesn't matter.
They haven't issued any similar guidance indicating that how they would exercise their discretion under the provisions we're actually concerned with, have they?
Well, no, my lord, because they believe that they...
No, but they haven't issued any guidance at all, either of this nature or any guidance.
No, they haven't issued guidance.
So we're wrestling with...
I would say there's nothing really...
May, without...
Yeah.
Can you help on one thing that's puzzling me? You did benefit, according to the statement of facts, of them allowing your appeal. It says at paragraph 6C that the revenue, quotes, the appeal was allowed by the HMRC. Now, as I understand it, the HMRC doesn't have any power to allow appeals. You have an appeal to the first-tier tribunal, which can allow your appeal. But it seems that the revenue regarded themselves as having some sort of power to, I don't know what, compromise the appeal.
Well, so that would be what it amounted to, is that they abandoned their decision.
But they talk about allowing the appeal, but that's wrong, isn't it?
But it's an internal review procedure, isn't it?
There is an internal review procedure.
Isn't that what they
bring an appeal to the revenue, and then they offer the review.
ED, but the letter says they're allowing the appeal. I mean, there are two things emerge from that. One is they clearly think they have some extra statutory power to do something like that. And two, there must be some grounds on which they exercise that discretion outside the statute.
Well, if we turn to what they did there, which is in the blue bundle, the core bundle, because they obviously did this twice.
Yeah.
Digging up the...
But it's in the appendix, which I have,
It is in the appendix.
page 85. Your appeal is upheld.
The...
Page 85, letter of the 20th of August 2010.
And there was a similar letter on the 12th of November 2009.
Yeah, I mean, they're not referring simply to an internal review. They're talking about allowing the appeal.
Well, I'm not sure. If you look at 82, they do refer to an internal appeal. Alternatively, they say, we'll tell you about your right to appeal to an independent tribunal. So they do seem to think
But they have an internal appeal.
they have some sort of internal...
I believe that is how the system is described, is that you appeal to the revenue, and then you appeal to the tribunal. I mean, it's true that it's a slightly confusing terminology.
But it's a purely non-statutory exercise, as I understand it. There's nothing in the statute about appealing, at least I haven't found it. Maybe there is.
They do have the power.
I see. Yes, I understand there's an internal review. That's, I think, what it is.
I certainly don't think that...
Do you have the reference, just the reference to that?
Section 49A of the Taxi Management Act,
Yes.
1970.
Right, and does it indicate any particular grounds on which the internal appeal may be allowed?
Can I check?
Yes.
I mean, according to the letter, he says he's prepared to overlook the failures, so it seems to be a discretionary thing.
Right.
But don't worry about it. It seemed to me to be a point possibly in your favour that the revenue do clearly exercise some sort of non-statutory discretionary review process.
Well, it is a point, and I think we make it in our case, that there were two examples where they effectively allowed our appeals for reasons which are not made clear, and which, in at least the first one, appear to include our submissions on proportionality.
So your basic point is that they appear to exercise discretion when it's clear there isn't one. So when there is one, why shouldn't they exercise it even more generously?
Yes, my lord, though I feel they probably did have the same discretion in both.
I mean, the question surely is what are the factors relevant to the discretion rather than whether it exists? I mean, on the face of it, this is purely part of the mechanics of collection, so that one would not expect factors to be relevant which had absolutely nothing to do with the efficiency of collection in the tax system.
Well, if we look at the factors that are relevant, that are in it, I'd say that it doesn't say on its face what is relevant and irrelevant. It's not. We provided some examples of cases where Parliament does exclude relevant features. They're provided in our case, and this isn't one like that, where they say you may not look at this factor. What is defined in 66 are the circumstances that give rise to the power to revoke, but it's not. The legal test of the existence of a power are not the same as the factors you consider when exercising the power. The revenue keeps saying that there is a closely articulated code for the grant or cancellation of gross payment, but there's a closely articulated code for the grant or the option to cancel gross payment. It is an option. And I'd say that generally it's actually surprising to say that you look at the same questions when deciding whether to exercise a power as when deciding whether or not you have that power. Because if the point of this is to weigh up your culpability, your risk of future failure, and your seriousness, the seriousness of the infraction, you've weighed all those up before the power arises. And that was exactly how the law used to work. That's been replaced by a defined system where you have a list of tolerable failures. So the starting point is that you've fallen out of that defined system. And so why should you be allowed through it if all that matters is how bad your failures are and the risk of future compliance? Because I would say that if you have a power to do something to somebody, which is take away gross payment status, and it's well known and was assumed throughout legislation that it is a serious advantage to have gross payment status. So whether it is a punishment or not, it's certainly a bad thing that's going to happen to them. And I would say that the three most obvious things that will pass through a decision maker's mind are how bad was what they did? Will it happen again? And what will happen if I use my power? You wouldn't normally say, well, how did that idea get into your head that you're going to think about what will happen if I use my power? It's something that naturally comes to mind. And so I'd say if it was supposed to be put out of the mind, they would have made that clear in the way they do in other parts of the code, the tax code. And that, given that it's quite clear that this is a benefit to someone, it's possible, or in fact probable, one of the reasons there is a discretion is to take that into account. It was well known from the 1970s that removing an advantageous trading status is worse than refusal to grant it in the first place, because you've already entered into your business relationships, hired your staff on that. I mean, we've put in Hook, but Lord Stenning and Scarman weren't cutting new ground in Hook. They were making a common sense point that taking away an advantageous status is more serious than refusing to grant it. And there is the point that the revenue concede and the Court of Appeal thought that this discretion is a protection for the taxpayer. If it is a protection, and I'd say it is a protection, it suggests the taxpayer has an interest to protect. And if they have an interest to protect, then it seems surprising you're not allowed to wonder about how bad your impact on that interest is. The revenue do say that this discretion should be exercised sometimes, and if I take you to what they say about that is again at 49.2. I think it's 109 in their case. 51.2. Where they say maybe exceptional circumstances in which a minor compliance failure occurs which is not addressed expressly or by implication in 32. But we've seen Regulation 32. It's a quite short list of clear examples. So a lot of minor failures will fall outside that list. But if you say, for example, you have a company, a large company, otherwise compliant, which notifies Companies House of a change of director 15 days after change rather than 14 days, so it's a day late. It's not in Regulation 32. There's nothing in Regulation 32 that's anything to do with that. But on what basis could the revenue let that company through? They've been asked to publish a list of tolerable failures. It's outside that. If the harm to the company, if the effects of their choice are irrelevant, then there's almost nothing else to think about, really. You know this is not defined as a tolerable failure in the published list. You know they don't have a reasonable excuse. They're not supposed to treat identical cases, materially identical cases, differently. I've put in the reference to Lord Scarman in the Federation of Small Businesses. But if the impact on the business is irrelevant, then it's hard to see what the discretion is for. It doesn't just bring back in the general judgment call about minor and technical that Parliament abolished 14 years ago. It also suggests then how is this discretion supposed to be reviewed by the tribunal? Because by definition, if you fall outside Regulation 32 and do not have a reasonable excuse, you can't really say, well, this was too trivial a failure, because the revenue have been told to define the trivial failures. You know what they are, you're outside them. You can't say it's excusable, because if it was excusable, you wouldn't be in the realm of the discretion at all. So what could make the revenue decision inappropriate, is the phrase they use, unless it's too harsh. It wouldn't. If it's inappropriate to sanction this company, which is 1 day late on its filing of Companies House, then it's inappropriate for everyone who does that, and it should be in Regulation 32. That's the point of Regulation 32. And so that's why I say it's that layer model of what discretion does seems to resurrect this minor and technical carve-out, which doesn't make sense now and made even less sense then, because then you had to exercise the discretion after you knew it wasn't minor and technical. I've said that actually the revenue would be able to manage with this. They manage in similar circumstances. They've produced guidance where they have to deal with this. They do finally say that a major financial impact would itself be a reason to cancel gross payment, because it means the subcontractor is unstable. Say two things in response to that. First, the fact the business has been into crisis by pulling the rug from under it in the terms of losing one of its trading tools doesn't mean it's unstable beforehand. Whitter is in fact an example. The First Tier Tribunal found, sort of if you look at 24 to 27, I'll just give you the reference for that in their decision. It's a well-established business, been going on for decades. Its major clients rely on gross payment status. We say in the case that the documents here go back to 2008, but it's clear from that passage that they've been trading under gross payment for much longer with no apparent objection from the revenue. So this wasn't an unstable business, but the removal causes serious harm. I think those are my submissions on construction. So,
Thank you very much indeed. Yes, Ms. Boyd. We really need copies of, it seems to me, the Section 49A of the Taxes Management Act, just to get a full picture of this. I mean, I haven't got...
Sorry, I'm being ushered.
I think, I mean, just having looked on the internet, the whole section seems to be of some interest. It's obviously quite a sophisticated scheme of review, but it'd be interesting to see to what extent it introduces completely open discretion, for example.
But I think this was all introduced at the time of the change of the tax appeal system, and it was brought into a new appeal structure.
Yes. Well, it's obvious. I mean, looking at the correspondence, it's obvious it led to a quite a sophisticated review. But on what principles we can think about later. Yes, Ms. Boyd.
My Lords, I'm going to address you on the A1P1 aspect of our claim. And what we say in overview is that if construing the statute without reference to human rights doesn't get you to the result that impact is a relevant consideration in the exercise of this discretion, then construing the statute by reference to human rights does get you there. And that's because a decision to cancel gross payment registration, GPR I will call it, under Section 66 is interference with the registrant's A1P1 rights that is required to be proportionate.
What is the right?
My Lord, I will come to that. We rely on two rights. Or two possessions for A1P1 purposes. And that's, of course, the first thing I need to establish in order to establish that A1P1 is engaged. I just note that the revenue didn't, in the proceedings below, contest that A1P1 was engaged or that cancellation of GPR involved interference with possessions. So that has arisen for the first time in their written case before your lordships. So you have nothing detailed in writing from us on that, but I will address it orally. And if A1P1 is engaged, then the second thing I need to establish is that the requirement of proportionality means that the revenue must be able to take into account the impact on the individual when it is considering whether or not to cancel GPR under Section 66, and in particular, that it's not sufficient, as the revenue says it is, simply to look at the CIS, the construction industry scheme, as a whole and conclude that it represents a legitimate approach by Parliament to a serious problem.
I mean, just so that I can follow this, the property that you're referring to, you're saying the certificate itself is property, are you?
My Lords, I'll address you now on the question of...
Well, it's simply that it's quite difficult unless one knows what the property is.
So there is no longer a physical certificate. That used to be how the scheme worked, but it no longer works. What you have instead is the status of gross payment registration. So presumably there's a register somewhere which lists you as enjoying this status.
What is that? That is a statutory right, is it? Is that property of that sort?
It is, my Lord. Well, there's a statutory right to the grant of that status if you fulfil certain conditions. And again, at entry level, the provisions are mandatory in the sense that if you fulfil those conditions, you must be granted that status if you apply for it. At exit point, the provision is discretionary in the sense that...
Well, it is, but essentially the Section 66 is the mirror image of Section 63. The grounds on which you can revoke a gross payment status are essentially that the qualifications which you needed to obtain it are no longer present. That's expressly the basis of subparagraph 1, but it's effectively true of 2 and 3 as well, because the requirements to qualify for the status in the first place, you have to show that you can be expected to comply with your tax obligations.
Yes.
So that the provision that you haven't done is likewise the mirror image. So essentially all this is doing is saying that you're entitled to a privilege, not absolutely, but on certain conditions, and if subsequently it appears that the conditions are not satisfied, well, you're no better off than if you hadn't got it.
Well, my Lord, those are questions about what the statute appears to mean on its face.
Yes. Well, I mean, I see that you've split this up, but it seems to me to be equally relevant to the human rights angle, because you only ever had a conditional property, a property which was conditional on your continuing to qualify for this privilege.
Well, my Lord, the status of gross payment registration, which, as Mr. Eadie says, is a creature of the statute, is, first of all, it's not the only possession we rely on.
Right. What's the other one?
Well, the first possession we rely on is the possession constituted by what the subcontractor is due under the contract for his services. Now, what Mr. Eadie says
it can't be in gross terms because you have to account for the tax.
Well, that's
All you
of
have
course
is a
correct,
cash
my
flow.
Lord.
You have a cash flow benefit.
You have to account for tax, but that doesn't mean that taxation is not an interference with an A1P1 possession. It's generally accepted that taxation is an interference with an A1P1 possession. So the mere fact that your entitlement under the contract is subject to tax, and indeed the mere fact that it may be subject to deduction at source, neither of those things means that legislation which provides for such deduction doesn't interfere with an A1P1 possession.
But wait a minute, you're not complaining about the tax itself, because one way or another that's going to be paid either by deduction, so it's not going to reach you, or else you're going to have to account for it once it has reached you. Mm-hmm. What you're complaining about, therefore, is the cash flow impact of not having it in your hands for a bit.
Yes, indeed.
I don't know how long is the bit? 3 months at the most, or what? Maybe this is anyway.
It's not material, we say. I mean,
it obviously is material.
The point is that,
in some sense,
the point is that what the subcontractor is due. I mean, this is simply at the level of establishing that A1P1 is engaged. What the subcontractor is due under the contract for his services is an A1P1 possession.
But it hasn't been interfered with. All that's happened is that a different procedural mechanism has been applied to the process of its collection.
My Lord, let me take you to a case which is in the supplementary bundle. It's a Strasbourg case. It's tab 61.
yes.
And it's NKM and Hungary. So this was a case in which legislation provided that civil servants whose employment was terminated would receive severance pay equivalent to a prescribed number of months' work. And the legislature subsequently enacted legislation which provided for severance to be taxed at 98% and for tax to be deducted at source. Now, the parties in fact agreed in that case that there was an interference, but the court conducted an analysis nonetheless, and picking their assessment up at paragraph 32, which is on page 1092 of the report. So at paragraph 32, they said, in the present circumstances, the nature of a possession calls for closer scrutiny in view of the fact that the applicant never actually possessed the entirety of the severance pay in question, the special tax having been directly withheld by the authorities. And then, moving on to paragraph 36 on the next page, the court finds that irrespective of whether the applicant received part of the severance pay with the obligation to report it and to pay in due course the applicable tax, or whether the tax is automatically deducted from the severance constitutes a substantive interest protected by Article 1, Protocol Number 1. For the court, it is undeniable that it has already been earned or is definitely payable, which turns it into a possession for the purposes of that provision. And then, skipping to the next paragraph, I mean, it's still within paragraph 36, but the next indentation, furthermore, the court would add that the very fact that tax was imposed on the income demonstrates that it was regarded as existing revenue by the state, it being inconceivable to impose tax on non-acquired property or revenue. So we say the same analysis applies here.
How do you apply that here?
Well, my lord, the gross sum that is due under the contract has already been earned and is definitely payable. A tax on that gross sum represents one form of A1P1 interference in the possessory interest that the subcontractor has in the gross sum, because it prevents you from retaining the entirety of what you've earned. But a provision or an administrative decision, the effect of which is that tax must be deducted at source, which is what a cancellation decision is, that represents a further interference because it prevents you even from receiving the entirety of what you have earned under the contract. So the gross sum, we say, is an A1P1 possession for convention purposes.
Well, is it the gross sum or the cash flow advantage, which is the relevant possession?
It's the gross sum that is the possession, we say. And the legislation
Well,
interferes.
It was a possession for however many months before you had to account to the revenue for it. So
Yes.
it is, in truth, what you've lost is
Yes.
the cash flow advantage of holding a gross sum. You haven't lost the gross sum.
No. That is the cash flow disadvantage is the impact of the interference in your peaceful enjoyment of your possession. The interference is constituted by legislation which prevents you from receiving and having the advantage of that sum, but the possession is constituted by the gross sum. So it may be that it's a control of use interference rather than a deprivation interference, because it prevents you from holding it in your hands.
The object of this submission, as I understand it, is not to say that they aren't entitled to revoke it, but to say that they ought to take hardship into account. But the hardship which you're relying on is not the cash flow difficulty, the problem which, if the advantage is a cash flow problem, the hardship is not the loss of it, but the fact that it is inconvenient to people to employ uncertificated contractors,
It is the
which is a completely different hardship. It's not got nothing to do with the particular characteristic of this arrangement that you're criticising.
My Lord, I'm still at the stage of just establishing that Article 1, Protocol 1 is engaged.
I see.
The question of what then needs to be considered in order to satisfy the requirements of proportionality is a separate question, which I will go on to. But you're right that the hardship relied on in this case is the impact of the A1P1 interference on the health of the business, consequent on removing the cash flow advantage and making you less attractive to contractors. So the first A1P1 possession, which brings us into A1P1 territory, is your possessory interest as a subcontractor in the gross sum due to you under the contract. But we say that GPR status itself is also a possession for the purposes of Article 1, Protocol 1. And the effect of that status is that you remain permitted to receive the entirety of what you have earned under the contract. So it prevents...
It's the same point, isn't it, under a different name?
Well, it is, my lord. It's the possessory interest wears two faces. But the first type of interest is not a creature of the statute. GPR status is a creature of the statute, but your interest in the entirety of what you are due under the contract is not something created by the statute. It transcends the statute, and it's something that the statute interferes with. And indeed, more to the point, a cancellation decision under Section 66 interferes with. as regards the possession constituted by GPR status itself, what Mr. Eadie says is that that status is a product of the CIS, and the CIS provides that it can be cancelled when Section 66 conditions are satisfied.
Well, he says it's only ever, if it's property, it's only ever conditional property. And the condition wasn't satisfied.
Well, that may be one way of putting it. But that argument overlooks, we say, the fact that removal of GPR is discretionary. So if we accept that if the statute said that when certain conditions were satisfied, then the status would cease automatically. For instance, if there was a time limit on the status.
You'd accept then that A1P1 wasn't engaged?
Well, we'd accept that a provision of that sort in the statute delineated the possession constituted by the status. So it would not be an interference with the possession for the status to terminate in accordance with the automatic provisions for termination. But we're not dealing here with automatic provisions for termination. We're dealing here with a provision which identifies circumstances that give rise to a discretion in the revenue to cancel.
But not an open-ended discretion. It's a discretion which has got to be exercised and so forth. It is within the scheme and for the purpose of the statute.
Well, indeed, my lord, but the scheme of the statute is to be read by reference to human rights.
Well, yes, but the scheme of the statute, obviously it has to comply with the Human Rights Act, it has to draw a fair balance. But that doesn't mean it's open-ended consideration of hardship.
No, my lord, that again...
I mean, in the case you pointed us to, NKM, it was clearly, they said, the question is, does it impose an unreasonable burden on her? And they decided it was, because she was taxed at effectively 98%.
My lord, again, I'm not at that stage of the argument yet.
No, I know you haven't, but actually, I'm afraid it's quite useful to look at where it's going.
By all means.
Otherwise, one gets into the salami approach, and it's not very helpful.
Yes, but they are analytically different steps, whether A1P1 is engaged at all, and whether proportionality requires consideration of impact if it is engaged. And on the subject of engagement, we rely on your possessory interest in what you're due under the contract. We also rely on the status itself, which is a possession, and we say that that possession is not delineated by by statutory provision that gives the revenue a discretion to cancel when certain circumstances arise, but doesn't require them to cancel in those circumstances. And one way of looking at it is to say that if GPR status is removed, that's not simply because the conditions for removal have arisen. It's because those conditions having arisen, the revenue have decided to cancel it. If the revenue decided not to cancel it in those circumstances, then the status, and we say the possession constituted by the status, would endure. So if the revenue do decide to cancel, then that involves taking away something that they would otherwise continue to enjoy. And that's sufficient to say there's an interference with a possession. So, my lord, moving on then to the question of what follows if A1P1 is engaged, there's a requirement that an interference with an A1P1 possession be proportionate, and that requirement means, we say, that the decision maker needs to be permitted to take into account the impact of the decision on the individual concerned. At a theoretical level, the relevance of the question of impact is clear from the way in which the requirements of proportionality have been formulated in recent case law, in particular Bank Mellat, which is at Authorities Bundle 3, tab 36, page number 1071, and turning that up quickly and taking it up at page 1142. The top of that page, this is a speech of my Lord Sumption identifying 4 steps in the assessment of proportionality.
Sorry, which page, please?
This is page 1142.
42, thank you very much.
It's at B of that page. So the third step is to consider whether a less intrusive measure could have been used, and the fourth is whether, having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. And turning to Lord Reed's speech at page 1162, Lord Reed, of course, agreed in substance with Lord Sumption's formulation, but he added, so this is at C, the final sentence in the first paragraph on 1162, in essence, the question at step 4 is whether the impact of the rights infringement is disproportionate to the likely benefit of the impugned measure. So we simply say it simply follows from what proportionality is and requires that impact is something you need to consider in order to be directing yourself properly to make a proportionate decision. And if a decision under Section 66 is required to be proportionate, it follows, we say, that the decision maker must be permitted to take the impact into account. And that reasoning is consistent with the Supreme Court's approach in Whitter, which was a case in which Article 1, Protocol 1 was engaged by confiscation provisions, and that is at Authorities Bundle 3, tab 33, page number 917. So this concerned a confiscation order made under Part 2 of Poker following Mr. Wyer's conviction for obtaining a mortgage by deception. It was heard by a 9-judge court, the court having identified as an issue of relevance whether the statutory regime might give rise to an order that violated A1P1 because it was disproportionate. And all 9 judges agreed with the analysis set out in the first 34 paragraphs of the judgment. And if I can pick it up on page 930, so paragraph 12 on page 930, it is clear law and was common ground between the parties that Article 1, Protocol 1 imports via the rule of fair balance the requirement that there must be a reasonable relationship of proportionality between the means employed by the state inter alia, the deprivation of property as a form of penalty, and the legitimate aim which is sought to be realised by the deprivation. Moving on to paragraph 13 on the next page, A1P1 is one of the convention rights to which the HRA applies. This means that under Section 3, so far as it is possible to do so, legislation must be read and given effect in a way which is compatible with it. And then paragraph 14, Mr. Perry QC for the Crown and Lord Panic QC for the Home Secretary both submitted that this means A, that poker must be read and given effect in a manner which avoids a violation of A1P1, B, that a confiscation order which did not conform to the test of proportionality would constitute such a violation, C, that it is incumbent upon the domestic court to provide a remedy for any such violation, and D, that the appropriate remedy lies in the duty of the Crown Court judge not to make an order which involves such a violation. These submissions are plainly correct.
How do we fit this case into the second paragraph of A1P1? The preceding provisions shall not, however, in any way impair the right of a state to enforce such laws as it deems necessary to secure the payment of taxes or other contributions or penalties.
Yes, so there is, of course, a wide margin of discretion afforded to states to legislate in taxation matters and other social and political matters as they deem necessary, but it's not untrammelled. It's subject to the requirement of proportionality.
Well, is it? Because the second paragraph is not framed as a justification of a prima facie breach, but as a qualification to the existence of the relevant protected right, isn't it?
Well, the question of whether an interference is necessary in accordance with the general interest is the question of proportionality. I believe that is how...
Whatever else this shows, doesn't it? It shows, as I think you accepted a moment ago, that there's some extra margin in this area.
We absolutely accept that, my lord.
I mean, you wouldn't, or would you suggest that the similar arguments could be deployed if someone, in relation to the compatibility with the convention of the actual scheme for applying for gross payment status? I mean, you could argue, couldn't you, that this is a very detailed scheme, unnecessarily so, if you can show that you're a reputable subcontractor and you're going to pay your taxes in other ways, and it'll harm your business if you don't get gross payment status straight away. Why should you have to go through all these detailed hurdles? Wouldn't a similar argument be available to you?
I'm sure a proportionality argument could, in principle, be levied at the scheme as a whole. I expect it would get pretty short shrift. Yeah. That's not our case. We are not attacking the scheme as a whole. We are not saying it strikes the wrong balance between the interests of the individual and the interests of the community. Our attack is directed at an administrative decision under a provision of the scheme that provides the public body with a discretion.
Yes. And
so the focus is on the constraints on the exercise of that discretion by the public body. Yeah. So, I'm sorry, I've put it away, but back on page 931, no, yeah, sorry, 931. The submissions by Mr. Perry and Lord Panic that were accepted there by the Supreme Court have application here as well, we say. Section 66 must be read and given effect to in a manner which avoids a violation of A1P1. That's on the assumption that A1P1 is engaged by the removal of gross payment registration. B, a cancellation decision which did not conform to the test of proportionality would constitute such a violation. C, it is incumbent upon the domestic court to provide a remedy. And D, we say the appropriate remedy lies in reading the discretion as subject to the requirement not to make a decision under Section 66 which is disproportionate. And in order for that to be possible, the decision maker has to be entitled to take impact on the registrant into account. And turning over the page quickly, paragraph 16 finally, the court considered it is plainly possible to read paragraph B, that's of the legislation, as subject to the qualification except insofar as an order would be disproportionate and thus a breach of Article 1, Protocol 1. It is necessary to do so in order to ensure that the statute remains convention compliant, as Parliament must, by Section 3 of the HRA, be taken to have intended that it should. So, in that case, the requirement of proportionality required a reading of the legislation on which individual impact could be taken into account, despite the fact that that was not what the statute seemed to say, if read without reference to human rights considerations. And that was also the effect of the Supreme Court's conclusions in Pinnock in an Article 8 context, and that again we have, I'm afraid, in the supplementary volume at tab 59. This case concerns Section 143D2 of the Housing Act 1996.
Sorry, which flag again?
It's tab 59 in the...
thank you.
In the so the relevant provision said that a court in possession proceedings must make an order for possession unless it thought the relevant procedure had not been followed. And Mr. Pinnock's complaint was that he had not, therefore, in application of that provision, been given an opportunity to raise with the court the question whether the order for possession was, in all the circumstances of his case, proportionate. Again, there was a 9-judge court considering that issue. Turning to page 114 of the report, Lord Neuberger's speech for the court. paragraph 2, you can see at A that the question was whether Article 8 required the court to have power to consider whether such an order would be proportionate, and if so, whether such a power could be read into the legislation. Both questions were answered in the affirmative, and the judgment contained lengthy consideration of relevant House of Lords and Strasbourg authority. And turning up to paragraph 49 of the judgment, page 126 of the report, you have the ultimate conclusion starting between A and B on the page. Therefore, if our law is to be compatible with Article 8, where a court is asked to make an order for possession of a person's home at the suit of the local authority, the court must have the power to assess the proportionality of making the order, and in making that assessment, to resolve any relevant dispute of fact. So again, the legislation appeared in that case to preclude the decision maker from taking the individual facts into account. But since convention rights were engaged, the court found it necessary to read the relevant power in under Section 3 of the Human Rights Act. The Court of Appeal case of Lindsay and the Upper Tribunal case of Total, which we've referred to in our written case, are judgments, we say, in the same vein. I don't ask you to turn them up because the references are in our written case and we're short of time. But in both cases, the court concluded that the principle of proportionality applied at the level of the individual decision, and that it was thus necessary to be able to examine the impact of a decision that engaged A1P1 on the individual affected.
Forgive me, the names of the cases again?
Lindsay,
yes.
That was in the Court of Appeal, and Total, which was the Upper Tribunal case. I can give you the bundle references. It's Authorities Bundle 119 and 335. Well, paragraphs 86 to 88 of our written case. So our starting point is a series of cases in which courts at various levels have held that where a decision engaged convention rights, including Article 1, Protocol 1, a convention requirement of proportionality required the decision maker to be empowered to make an assessment of impact at the level of the individual decision. Now, the central point of dispute in this case on this subject is whether the convention similarly requires that a decision maker under Section 66 must be able to consider individual impact, so that such a power must be read in if it is not already there, or whether the cases and the principles on which the revenue rely mean that, contrary to the approach in the cases I've mentioned, proportionality only needs to be assessed at the level of the scheme as a whole. The Court of Appeal held that the proportionality of the CIS would speak for the proportionality of individual decisions under Section 66 in all but exceptional cases, and that's paragraph 79 of Lord Justice Henderson's judgment. The defendant goes further than this, the respondent goes further than this and says that the proportionality of the scheme makes the decision under Section 66 proportionate in all cases, such that individual impact never needs to be considered. We say both of those are wrong, relying on the cases that I've mentioned. The Convention requires that a decision maker under Section 66 be permitted to consider the impact of cancellation in any case, if it is raised, as it was in this case. That doesn't mean, of course, that impact will necessarily count for very much in that balance. And addressing my Lord Sumption's suggestion that if there's such a power, then hardship must carry the day, that's not at all our suggestion, nor do we say it's an implication of a conclusion that hardship in principle needs to be considered. Weight is absolutely a matter for the decision maker. But we say
the hardship is going to be exactly the same in every case, isn't it? The hardship on the agreed facts is going to be in the mere fact that not having the status makes you an unattractive subcontractor. That's going to be the same for everybody.
It will differ, my lord, according to the particular circumstances of the subcontractor. So in this case, because the subcontractor may have many clients who require gross payment registration as a condition of engaging them, or few such clients. And in this case...
Well, I thought the agreed fact was that that the general position in this trade is that people are reluctant to employ uncertified contractors.
That is...
And so, I can't see what the special factors might be that differentiate one case from another.
It may simply, as a matter of fact, be the case that the subcontractor in question has contractors who don't much care whether they are registered for gross payment or not. In this case, a large number of the, well, in fact, it's one. So I'm grateful Mr. Chaco's pointed out that the first tier tribunal found the specific harm and the specific effects that would be suffered in this case, which is at page 188 of the core volume. Paragraph 47, yes. So this is the specific circumstances of this case are that a lot of Whitter's revenue derives from one particular contractor who are likely to withdraw work if they lost their gross payment status. And there was specific evidence on that point, and it was accepted that because of the specific circumstances of this subcontractor, the business would take 10 years to recover if gross payment status was removed. And it's worth pointing out that the implication of the revenues position, which is that impact cannot be taken into account, the revenue are prohibited from taking it into account, is that even in an extreme case where you had a subcontractor who, on the evidence, plainly would go out of business with significant unemployment as a result, and where the default for which their gross payment status is being removed is a minor one, a trivial one that can't possibly raise any serious concerns as to their ongoing tax compliance. Even in such a case, the revenue would be prohibited from taking the impact on the subcontractor into account when deciding whether or not to cancel. And that's, on its face, implausible, or at least uncomfortable. So turning to the revenues argument for the proposition that it's sufficient to satisfy the requirements of proportionality that the scheme as a whole be proportionate. They rely on three propositions. First, that Parliament enjoys a wide margin of appreciation under A1P1 in the context of the power to raise and collect tax. Secondly, that the CIS is a measured solution to a real problem and can't be said to strike a balance that is manifestly unreasonable. And thirdly, that measures of general application can in principle be inoffensive to the Convention.
Sorry, that's no doubt quoting from that case.
It's paraphrasing.
Paraphrasing, right, yes.
Mr. Eady will object if I've misled you in any way. But those, no, I understand to be their three central propositions.
Yes.
Now, in fact, all of that really is common ground. We agree there's a wide margin of appreciation. We agree that the CIS pursues a legitimate aim in seeking to counteract tax avoidance by subcontractors. As Mr. Chaco said, we don't accept that part of the central legislative aim is to improve compliance with tax legislation generally. We agree that the scheme is measured and contains a number of protections for the taxpayer, and it cannot, at the general level, be said to be manifestly without reasonable foundation or to impose burdens on the individual that are manifestly excessive. That's not our complaint. And we agree, finally, that the Strasbourg Court has recognised that measures of general application can, in principle, be inoffensive to relevant rights under the Convention, notwithstanding that the application of such general measures may entail individual sacrifices to the scheme. So we agree with all of that. We say it's beside the point, and that's for two reasons. First, Section 66 is not a measure of general application in the relevant sense. It is not a blanket provision that enacts a general rule that applies regardless of circumstances. It provides the revenue with a discretion as to what to do when the conditions which permit cancellation are satisfied. There are three Strasbourg cases in the bundles in which a general measure, a blanket provision, was held to be acceptable. And I'm not asking you to turn them up at this stage, but each concerned a general rule that had been legislated for, and the complaint concerned the proportionality of that general rule. One is James in the UK, which was the challenge to the Leasehold Reform Act 1967, which provided for the compulsory purchase of bits of the Duke of Westminster's estate. Parliament had provided there that where the relevant conditions were met, the applicant's property would be subject to a compulsory purchase. The second is Zdanoka and Latvia, where the legislation under challenge prohibited people who had previously participated in the Communist Party of Latvia from standing for election. And the third is Animal Defenders in the UK, which concerned the proportionality of a general measure that prohibited broadcasts of a political nature. So in each case, the interference in rights at the individual level simply followed from what the legislature had prescribed at the general level. And that is why proportionality is supposed to be assessed at the general level. By contrast, when a taxpayer's registration is cancelled under Section 66, that cancellation is not the application of an invariable general rule reflecting a balance of rights and interests that Parliament has struck. And when we complain about the Section 66 decision in our case, we're not in the territory of inviting the court to interfere with a balance that Parliament has struck. Parliament could have chosen to strike the balance in a particular place. It could, in principle, have enacted a measure of general application requiring GPR to be cancelled when the Section 66(1) conditions arise. And if it had done that, then it might be right that the question of proportionality would have arisen at the general level and could have been satisfied at the general level. And I say might because, for reasons I'm going to go on to, we don't say it inevitably would have been sufficient. But in any event, that's not what Parliament has done. And so the in-principle acceptability of measures of general application is beside the point. What we say is that having chosen to provide a discretion rather than decide the matter itself, what Parliament cannot do, consistently with the Convention, is to tie the decision-maker's hands by prohibiting consideration of those factors that are necessary to assess proportionality in exercise of the discretion. Where Parliament has left it to the individual must have the power to respect the requirements of proportionality. And that's an analysis, we say, that derives support from the concurring opinion of Judge Bratzer in Animal Defenders. This is Authorities Bundle 5, tab 54, turning it up at page 1951. Paragraph OI4, and picking it up...
554, paragraph.
Paragraph OI4 on page 1951. Picking it up at the second sentence, Judge Bratzer says there is, where the interference is the result of an individual decision, the court's approach has been to examine the necessity and proportionality of the restriction in the particular circumstances of the case.
Isn't there an element of circularity in the argument here? You say Parliament didn't tie the revenue's hands to preclude it examining individual circumstances. It gave an individual choice. But doesn't that beg the question, as a matter of construction, is the word may here really intended to open the field to any sort of hardship argument, or is it not intended to reflect a much narrower scheme, something much more consistent with the type of conditions which the scheme expresses?
My Lord, no, it's not circular, and let me try and explain why. The point is that cancellation is discretionary. We don't rely, for the purpose of this argument, on a premise that the discretion includes the ability to look at impact. We would just rely on the fact that it's discretionary. And the effect of the fact that it's discretionary is that Parliament has not said, in circumstances where these the listed circumstances, we have determined that the proper balance between rights and the public interest is struck by individuals having their GPR removed.
Does the discretionary, I mean, doesn't it make it matter for this purpose whether hardship is relevant to the discretion as a matter of statutory construction? I mean, you seem to be distinguishing between a case where the statute says there's no discretion, you've got to revoke, and a case where the statute says you don't have to revoke, but the grounds on which you make that decision can't include hardship.
Yes.
You say there is a distinction.
I say there's a distinction, my lord. And what I say is that I don't say...
What is the basis of the distinction? Because if there's no discretion, equally, that's tantamount to saying you can't consider hardship. Just means you can't consider a whole heap of other things either.
Well, if there were no discretion and it were mandatory, then the provision would reflect a decision that Parliament had made about when rights should be interfered with in this way.
Yes.
And then we'd be in the territory of the margin of
But
appreciation.
why isn't that equally true of a case where Parliament has said, OK, you've got a discretion, but it doesn't extend to taking hardship into account?
Because however wide the margin of discretion is, it doesn't permit Parliament to legislate out of the requirements of proportionality.
But what I see, well, that would mean that if it was of the nature which Lord Sumption has mentioned, in other words, if it was a discretion which excluded factors such as general hardship, then that would be what Parliament had said, and you would challenge actually the compatibility of the primary legislation.
Yes, indeed, my lord. That is what we say, and that's what...
Well, I mean, it may...
That may be the position.
That might be the position.
It may be, though one thing
right.
I'd say in this regard is that it's not the question of statutory construction and the question of what human rights require are not cleanly divisible in this way, in the way that the Revenue has tried to set it up, indeed, in their written case. And that's because the question of what human rights require is as relevant to the question of construction as anything else.
Even Section 3, we can, courts can do
not merely
heroic
under Section
things.
3, but under ordinary domestic principles.
Yeah.
In fact, let me take you quickly to what Lord Hoffman said about this in Wilkinson, thank you.
I mean, it's linked with ex parte sims and all sorts of rules of construction. I think we're familiar with how
Well, I don't need to take you there. The point is that we don't accept that if we are right on what human rights requires, that amounts to imposing through a human rights lens something on Parliament that it didn't intend. What you have here is a discretion with no guidance in the statute, we say, as to what its constraints are. And we're in the business of construing the bounds of that discretion. This isn't a case in which, like in Wire and in Pinnock, where the statute on its face didn't permit consideration of impact, and the court nonetheless felt that it had to read it in under Section 3. This isn't even such a case because there's almost nothing in the statute to suggest what the bounds of this discretion are supposed to be, or by reference to what it's supposed to be exercised. But if I can just finish that quotation from Judge Bratzer in the Caring Opinion, because he draws this distinction between an interference that simply follows from what Parliament has said, because there's a general rule that Parliament has legislated for, and an interference that is the result of an individual decision. And he says, where it's the result of an individual decision, the court's approach has been to examine necessity and proportionality of the restriction in the particular circumstances of the case, where, however, as here, the interference springs directly from a statutory provision which prohibits or restricts the exercise of convention rights. The court's approach has tended to be different. In such a case, the court's approach is not on the court's focus is not on the circumstances of the individual applicant although he must be affected in order to be a victim. It is instead primarily on the question of whether the legislature itself acted within its margin of appreciation and satisfied the requirements of necessity and proportionality when imposing the prohibition or restriction in question. So what we say is that a cancellation decision under Section 66 does not spring directly from the statute. So an examination of the proportionality of the statute will not suffice to establish the proportionality of such a decision. And that argument, I say, is not circular. It doesn't rely on taking as a premise that impact is a relevant consideration in exercise of the discretion. It has that as an output, that conclusion, and that's because if Parliament has legislated for a discretion, what it can't do is prevent the decision maker from exercising that discretion in a proportionate way.
Well, if one had concluded that if Parliament had said in the most clear and express terms this loss of registration is automatic once you no longer comply, and one had concluded that that wasn't, that taken something in the scheme as a whole was within margin of appreciation, perhaps because it's a revenue collecting provision. It seems very odd that if Parliament then says, well, we will give you a very limited discretion, but that's not to extend to an impact assessment. You say that then that would not be capable of being saved by a margin of appreciation, even though it ameliorates what would otherwise have been a more rigid provision.
I do say that, my lord.
You really get that out of this passage?
Well, it's a difference between a case where Parliament has decided what happens in the individual case and where Parliament hasn't decided what happens.
But it's not a black... I mean, I can quite see that at opposite ends of the spectrum there may be something which is automatic at one end and something where the court has an uncontrolled, or the decision maker, an uncontrolled, not uncontrolled, but a completely general discretion at the end. But we're operating within those two extremes with a difficult question of construction as to just what measure of discretion there is.
Well, my lord, let me maybe move on to the second point I make, because even if, contrary to what I have said, Section 66 was a general measure, which could in principle be justified at the general level, that we say only gets you so far. Notwithstanding the margin of appreciation, the mere fact that Parliament has legislated for a general scheme that is not manifestly unreasonable does not in itself establish that any application of the scheme will pass the proportionality test. If it did, the court would not have decided as it did in Rasgar and Pinnock and Whitter. And we say that the point is clear, moreover, from the reasoning of the courts in the cases that the respondent relies on. The most recent Strasbourg case invoked in support of the proposition that measures of general application may be acceptable is animal defenders. And that is at Authorities Bundle 5, tab 54. Page 1909 is where it starts.
Forgive me, Ms. Wood, I know you're racing against the clock. What's your submission?
My submission.
Yes. Even if 66 was a general measure.
Is that the fact that Parliament has legislated for a general measure only gets you so far. It doesn't establish that the individual decision is not required to be proportionate, notwithstanding the wide margin of appreciation. And we say that it is evident from the fact that in Rasgar and Pinnock and Whitter, notwithstanding that there was no attack on the general scheme, the court said that at the level of the individual decision you had to read in a power to consider impact. And we say it's also clear, in fact, from the cases that Mr. Eady relies on in relation to this point, in particular animal defenders and Lawrence and Fenn Tigers. Now, I'm running out of time, so let me simply try and compress what we take from those cases. In those cases, the Strasbourg Court and the Supreme Court, respectively, did indeed reach the conclusion that the measure of general application that had been legislated for was within the margin of discretion. But it did so following a very detailed painstaking scrutiny of the case that had been made by the state for generality in itself. And in the case of animal defenders, which is a prohibition on broadcasts of a political nature, it recorded the House of Lords' finding that a blanket prohibition was necessary to avoid the risk of advertisements by organisations with objectionable goals. A less restrictive prohibition could have been circumvented and would be difficult to apply objectively and coherently, making it more difficult for broadcasters to fulfil their duty of impartiality. In Lawrence and Fenn Tigers, which was a challenge to the costs regime, similarly, there was painstaking consideration of the rationale for a general provision, and in particular for generality at this level. And the point we make is that where the question concerns the convention compatibility of a general measure, which entails hard cases but is said to be proportionate overall, far from it being a matter of rubber stamping such a measure by reference to the margin of appreciation, both the Strasbourg Court and this Court have approached the issue by means of examining the case for generality, of whether hard cases are really inevitable, and of the degree of scrutiny which Parliament has given to the issue. So it's all very well to say that in principle, general measures may be acceptable, but in the present case we say no convincing argument for generality has been made at all. The only consideration that has been offered up by the Revenue as warranting a scheme which ignores impact in the individual case is at paragraph 74 of their written case, which is page 116. And there they say, the imposition of a requirement or entitlement on the part of HMRC to consider the potential impact on the taxpayer of the exercise of powers under Section 66 would risk undermining the evident purpose of the legislative regime to ensure strict compliance with tax obligations and would lead to uncertainty and administrative unworkability. But first, for reasons already given, we don't accept that the legislative objective is to ensure strict compliance with tax obligations, and it's not clear how the real objective, which is to prevent tax avoidance, would be undermined by a power to take individual impact into account. Secondly, no convincing arguments for uncertainty or administrative unworkability have been made, and it can be borne in mind that impact need only be considered on our case if it's raised. It won't be raised in every case. Thirdly, there's nothing before the court to suggest either that Parliament made a deliberate legislative choice to prohibit consideration of impact, or if it did, that it had good reasons for doing so, or what those reasons were. So in those circumstances, we say there's no basis on which the court could properly find that Section 66, construed as the Revenue wished to construe it, represents a legislative choice by Parliament, the generality of which is a necessary evil. And that, we say, looking at animal defenders and Lawrence and Fenn Tigers, is what would have to be established if proportionality at the level of the general scheme were to suffice for purposes of the Convention.
Say that again, what would have to be precisely established?
What would have to be established is that a restriction on Section 66 that prevents impact from being taken into account in every case, no matter how severe the impact, represents a legislative choice by Parliament, the generality of which is a necessary evil. So it's not just even the fact that it's a legislative choice by Parliament, it's that Parliament had good reasons, sufficiently good reasons, for legislating generally in that way. And we say there's nothing before the court to base those conclusions on. My Lords, unless I can assist further, those are my submissions on proportionality.
Thank you very much.
My Lords, so far as the facts are concerned, I can be very short indeed. They are encapsulated in the upper tribunal's judgment in a single, slightly long paragraph, paragraph 3, on MS page 148 in the core volume. And in the Court of Appeal's judgment between paragraphs 4 and 16, and there are perhaps only 4 facts of relevance for the purpose of this appeal. Firstly, the taxpayer had failed the previous 2 reviews in July 2009 and in June 2010, before the privilege was withdrawn, when they failed the next one in May 2011. Secondly, on both previous occasions, HMRC had made it clear to the accountants for the taxpayer, and that clarity, as the tribunals found, had been passed on to the executive manager of the business. They had made clear the grounds for cancellation, so the seriousness and the consequences were crystal clear, and the need for strict future compliance. There would, as it was put on one occasion, be no room for further failures. Thirdly, starts with a yet. Yet nothing was done to correct the relevant systemic error that had led to repeated late payments of PAYE. They were said in the letter from the taxpayer inviting the exercise of the reasonable excuse exception to be, quote, administrative errors. That's recorded in the upper tribunal's judgment at paragraph 3.0. That was rejected by the first tier tribunal and the upper tribunal, who held as a fact that the taxpayer had chosen, their word, not to address the matter and not to improve the system despite previous year's failures and despite the warnings. And it is no doubt for that reason that it is now accepted by the taxpayer that it did not have a reasonable excuse for the purposes of the legislation. Fourthly, the consequence of cancellation was seriousness. And it appears, we respectfully agree with Lord Zumption, we had always understood that that consequence was likely, depending on different degrees of seriousness, but that consequence was likely to flow whenever this cancellation is instigated. And that is, if you will, the flip side of the fact that the scheme confers a privilege. But the facts, so far as that are concerned, are that the tribunals found that major customers were likely to withdraw work, that there might be a fall of around 63% in the turnover or the profits of the company, and it would take 10 or so years to get back on its feet. Of course, the position is, to come to a question my Lord Culmworth asked, the position is that up till this point, they have been able to carry on with all the lengthy period that has passed.
It is a slightly odd position. I mean, do you accept that they have in fact complied over this period, or don't you know?
Well, my Lord, at the moment, I think the indications from the tribunal judgments are that there haven't been any further failures after they reformed the system, whenever it was, when finally it was cancelled.
And is there any, I mean, assume the position is that they failed back in 2010-11, but have complied ever since then and employing lots of people. Is there any discretion in the, if we were to uphold the appeal, or to dismiss the appeal, is there any discretion in the revenue to say, well,
just carry it on?
You proved your case? I'm
not sure there is. I think the relevant statutory provisions for the purpose of that question are 66.8 and 67.5, and it looks like you get the benefit as the taxpayer of continued gross payment status until, or unless and until, the appeal process is finished.
Then you
only then can you cancel, but after you've cancelled, you can only reapply for a year.
So you've got a year's,
You've got plenty of time to set up a wholly owned subsidiary and start it trading, so that when the time comes, it's fully compliant with the requirements, which are automatic.
My Lord, I'm not even going to offer a view on that potential avoidance mechanism, if that's the right way of describing it. Because I would be shouting that very loudly from those behind me, I suspect. But there may be all sorts of different issues that might arise But as we see it on the face of the statute, as long as it's the same individual, you do have, as it were, the oddity of a 10-year appeal process, everything being tickety-boo at the end of it, but you're still having to have the year.
Yes.
That may raise different questions. But those are the facts. That's all you need, I respectfully submit, in relation to the facts. So can I turn then to the issue of statutory interpretation? And just to start, if I may, with some very brief submissions on the relevant principles that apply to that exercise. My Lords, I'm sure, will be extremely familiar with the cartoon case, Khatun, which is in Bundle 2, tab 23. The relevant parts of it are 34 to 36, page 638 to 9. It's a judgment of Lord Justice Lord some time back in a Court of Appeal also comprising Lord Justice Wilson, as he then was, and Lord Justice Old. And it dealt with mandatory relevant considerations. I'm not inviting you to turn it up now because I'm going to take you to a more recent authority, which was to do with the challenge to the Parole Board's decision to release Mr. Warboys, which came before a three-person divisional court very recently, judgment being handed down by the divisional court, I think a matter of months ago. And I wanted just very briefly to take you to that, if I may. It's in the little supplemental bundle that you've got, and we will ensure that it eventually gets onto a memory stick. But it is the judgment of the President of the Queen's Bench Division, Mr. Justice Jay and Mr. Justice Garman. I'm not quite sure where you've got it, as it were, but it's probably right at the very back.
Yeah.
I don't know.
Yes, I think it is right at the back.
Yes.
It is right at the back.
Yes.
And for this purpose,
Yeah.
it's around about para 134 is the section that we are concerned with, and you see the title above 164, failure to have regard to relevant considerations, and you'll see from 140 that they cite Lord Justice Laws, but it's quite a helpful collection or collation between 136 principally down to the end of 141 of the way in which the doctrine of relevant consideration, mandatory relevant consideration, operates. And perhaps all you really need for present purposes is para 136 in the very well-known citation from the In re Findlay case, the speech of Lord Scarman, where he cited Mr. Justice Cook, as he then was, in Creed NZ. Can I just invite you to read that quotation from Lord Scarman quoting Creed NZ? And so what the court then does is to identify that as one of the principles, but to identify a related principle. And the related principle is that there may be some cases where you can't derive that mandatory lexicon, as it were, from the relevant legislation, but it is nevertheless possible to challenge in public law on the basis that the particular factor or feature is so obviously relevant that it would be Wednesbury unreasonable not to take it into account. And they distinguish between those two for an important distinction for the purposes of that case, perhaps not so much for ours. But you see the nature of the mandatory relevant consideration test in that quotation at 136, and you see how the divisional court have taken that principle, in effect drawing in well-known passages from Morgan Grenfell, Lord Hobhouse, about necessary implication, and Lord Nichols in B minor. The point about implication flowing, as it were, as a matter of logic rather than reasonableness. And they no doubt go to that place for mandatory relevant consideration. They no doubt go there because to imply that something is a mandatory relevant consideration into a scheme is quite a big thing when Parliament hasn't expressly said so, and is also quite a big thing because it would be to displace the rule that would otherwise apply, which is that those factors that a decision maker has to take into account are matters for rational judgment by the decision maker. So there are the principles to do with mandatory consideration. Of course, one also has to bear in mind in all of this, particularly when one's looking at a schematic issue of the kind that you have before you now, that even leaving aside mandatory relevant consideration, there is a Padfield constraint on generally expressed powers. In other words, if you simply had a generally expressed power, that power is not unconstrained by law. It would need to be exercised at the very least consistently with, or as it's sometimes put, so as to promote the purposes of the relevant statutory scheme. And if it doesn't, you can't exercise the power consistently with that constraining principle. So those are the basic principles.
Isn't there another one? Isn't there a principle that although in some circumstances, such as those which Mr. Justice Cook was referring to in the New Zealand case, a statute may permit but not require consideration of certain matters. I have a feeling he was talking about international law there, but I may be wrong. The position is different if you're talking about fundamental rights. If there's an impact on fundamental rights, don't you have to, or isn't there an argument you have to take them into account?
My Lord, there is. I was leaving entirely on one side the HRA.
Yes.
You don't need me to tell you that Section 6 of the HRA requires public authorities to exercise their powers compatibly with the Convention. Right. I'm leaving that entirely on one side. I'm simply on the point of statutory interpretation for the moment.
Well, the two are inseparable, aren't they? Ultimately, I mean, the HRA comes in...
at the point of exercising the discretion.
Yes, and it also comes in as a matter of interpretation as to what the discretion requires.
I'm not sure I will accept that. I mean, there are two different things in the HRA, aren't there? One of them is the Section 6 thing, yes. And that says if you're exercising a discretion, you've got to do it conformably to Convention rights. And the second of them is the Section 3 thing, yes. And that's a principle that allows the court to do heroic things by way of interpretation. There are obviously limits on that because it's got to be interpretation and not legislation and all of that. Right. But that principle only applies if on an ordinary set of interpretive principles, the court concludes that the legislation would, as legislation, otherwise be incompatible. Yes. That goes back to Lord Wolfe in Poplar Housing and all of that line of cases. But so they're two slightly different things. But the base point my Lord puts to me, does the discretion have to be exercised compatibly? Answer plainly yes. That's why we've got the A1P1 issue.
Yeah, right. We come to
but that's
that.
Can
I just test where the cases or the principles collected in the War Boys case impact here? They appear to be about where the circumstances in which you find a mandatory have regard to provision. We're here concerned on your main submission with a mandatory disregard.
We are.
Because you say the revenue may not take impact into account.
That's true, and that's why Padfield is relevant, because you have to exercise the power anyway, conformably with the purpose of the statute. And the reason I go to mandatory relevant consideration, otherwise the flip side of the point my Lord has just put to me, is because if you reach the conclusion that these considerations are not mandatorily relevant, you've gone a long way down the interpretive road towards Padfield, if I could put it that way. It doesn't completely get you there, but it means you look to see whether Parliament has concluded that something is relevant to the exercise of that power, and then you look to see whether it said, well, you have to take it into account. But if you're there, you're already in the exercise of statutory interpretation. So when we're dealing, as we are here, with as I called it, a schematic argument, in other words, an argument about the structure of the legislation, the purpose of the legislation, we respectfully submit that they're really flip sides of the same coin. One could have very different considerations if you were thinking about an individual case exercise of discretion, but that's not this debate. This debate is about the structure and form of the legislation and its purposes. Can I turn to that then, with those principles in mind? What are the key features of this legislative scheme, bearing in mind those particular features. And we respectfully submit that there are 6 main features of the scheme that the court may need to take into account. Firstly, the purpose of the construction industry scheme, of which this power is an integral part. The purpose of that scheme was to avoid, as I think we're all agreed, the very serious problems of widespread tax evasion in the construction industry. See Court of Appeal, para 56, Upper Tribunal, para 63, both of them citing and relying upon Mr. Justice Ferris in the Vicky case that you were taken to this morning. Won't go back to it. The relevant citation is quoted in the Court of Appeal's judgment at paragraph 3. And the purpose of that regime is to ensure the collection of tax, therefore, and prevent evasion in the context of an industry where beforehand, before its introduction, evasion was rife. And of course, it's essential to note that this is a collection scheme. It isn't a scheme for the imposition of tax. It's about tax collection. And the power in question is thus, as we respectfully submit the Court of Appeal at paragraph 66 rightly concluded, the power in question thus, as they put it, takes its place and has to be construed as part of a closely articulated code designed to combat tax evasion. Indeed, it might be thought that the very base purpose of this power is to cancel a subsisting registration for gross payment. So that's the first point, purpose. The second point is that that purpose led Parliament to devise a scheme which is properly described as tightly constructed, see the Court of Appeal, para 60, and which is characterised, see the Court of Appeal, para 57, by, quote, its stringency and prescriptive nature. And those detailed requirements and the degree of prescription were evidently intended by Parliament to be used and were judged by Parliament to be necessary and appropriate to ensure the effective collection of tax. I'm not going to go through all of the relevant provisions. They are annexed, it might be thought very helpfully, in a collection to the Upper Tribunal's judgment, MS 171 to 176, which effectively pulls together the key provisions in the primary legislation and also in the relevant regulations that were made pursuant to the enabling powers in Schedule 11, notably Regulation 32 in the box. And they're also described in some detail by the Court of Appeal between paras 20 and 33. But under that scheme, as again the Court of Appeal concluded this time at para 72, registration is, as they put it, a privilege which has to be earned by satisfying various conditions and which is liable to be lost if those conditions are no longer satisfied. So you have, just to pick up the key ones, you have the application for registration. That, as you know, is based on a duty to register if the conditions are satisfied. But the default position under the scheme is that you don't get the privilege. You've got to earn the privilege by satisfying the conditions. It's only if those stringent conditions are met that that privilege is afforded, and those conditions are then set out via section 64.4 in part 3 of Schedule 11. And so far as relevant, they include the turnover test, a minimum level of turnover in the next year following the application. There may, of course, be only limited control that the taxpayer exerts over its turnover, because it might be subject to other market forces. But it is illustrative, perhaps, of a key focus of the regime and its key aim being, in effect, to protect the exchequer by strictly protecting the effectiveness of the collection system that it sets up. So you've got the turnover test, then you've got the compliance test. Effectively, what has to happen is that the taxpayer has to have complied with all of the obligations that the tax legislation has imposed upon them in the last 12 months before the application is made. That's the basic rule. And that is subject only to the exceptions provided relevantly to the exceptions provided for in regulations. And the relevant one is Regulation 32, which prescribes a degree of tolerance within that regime. And the relevant box, if you want the relevant box in Table 3 of Reg 32, is the second one for our purposes.
Page?
Well, it's page MS 175 if you're going by the upper tribunal number.
Yes, correct. Yeah.
If you're going to the summary annexed to the upper tribunal,
Yeah, no,
175.
yeah, the second one, yeah.
And the failures here were to do with the obligation to pay B, tax liable to be deducted under PAYE. So the default position, the principal obligation is to comply with everything in the tax legislation. You've got some minor failures in that box identified with a degree of tolerance or a degree of give in the basic structure of the legislation. And then you've got, in paragraph 12.3 of Schedule 11, the reasonable excuse for failure to comply. So the basic position is subject to the exceptions or regulations, or if HMRC are of the opinion that the company had a reasonable excuse for failure to comply for as long as the failure lasted. That's 12.3 of Schedule 11. But it isn't just the tax obligations they have to comply with. They also have to comply, if one goes back to Schedule 11 in paragraph 12, they also have to comply, as you see from 12 sub 4, they have to have made the relevant national insurance contributions in the last 12 months, sub 4 of para 12. They have to have complied with the Companies Act obligations in the last 12 months, see 12.5. And it is to be noted that in relation to those two obligations of compliance, there are no exceptions to the failure that would otherwise follow. So there isn't a reasonable excuse failure, a reasonable excuse provision built into those 12.4 and 12.5 failures, as the Court of Appeal pointed out at para 27. I'll come back to the significance of that. And you will also note for this purpose, it isn't, I think, in the schedule to the upper tribunal, but 12.8, you might just note next door to that, a failure for these purposes includes a failure to do things on time. So it isn't just an absolute failure. If you do it outside the time, you're taken to have failed. So those are the elements of the compliance test. It has a retrospective element in that sense. You've got to have complied in the 12 months before the application is made, but it's also got a prospective element because there must be reason to expect that the taxpayer will comply with all of the relevant requirements in the next periods. See 12.7 of the regime, paragraph 12.7 of Schedule 11. So those are the conditions to registration, and if you satisfy all of those strict conditions, the duty cuts in. But they are premised on the satisfaction of those conditions before the privilege is afforded. Then one has the cancellation provision and a reversion, as it were, to the default position if you've had the privilege accorded to you. And the relevant key precondition is 66(1)(a), here failure to pay PAYE on time. I should have mentioned my Lord Lloyd Jones was exactly right. As you see from, if you just go back to page 175 and table 3, I identified the obligation to pay, the relevant one as being the tax liable to be deducted under PAYE obligations. And if you just cast your eyes to the right of that second box, you will see the point that I think my Lord was making, which is you get some forgiveness in terms of lateness of payments, which would otherwise have applied in the case of this company, but you don't get that forgiveness if it is repetitive. The key feature, perhaps, of cancellation is to note that it is, in effect, the mirror image of the conferral of the privilege in the first place. Exactly the same conditions apply, and that's deeply unsurprising, it might be thought. I'll come back to the significance of the discretion in a moment, but the conditions are effectively the same as one would expect. This is part of a coherent scheme, a whole scheme, in which Parliament's intention is evidently to set out the conditions that it considers appropriate to mitigate the risks that this scheme is designed to avoid, the historically demonstrated risks that this scheme is designed to avoid. And perhaps that point is best summarised by the upper tribunal in their judgment at paragraph 64, where they said that a person, I'm quoting, stand it up, a person should retain his registration only if he continues to display an adequate track record. The power to cancel registration is there principally to ensure compliance with the substance of the CIS. In other words, the idea is that persons who retain their registration should comply with the requirements of the regime. And so the punchlines of this second point about detailed prescription, we have here a scheme which is where the highly prescriptive detail is either set out in primary legislation or is enabled by it. It isn't a scheme based on broad discretion in terms of structure or detail. It is highly prescriptive. And it is stringent. That stringency is deliberate in the light of the overall aim of the legislative scheme, which is to ensure the effective collection of tax. Only those who can be clearly trusted and relied upon to conform to the letter of the law and the tax collection regimes more generally will be afforded the privilege of gross payment status. And that stringency is illustrated by the numbers that the Court of Appeal was provided with and that they record at paragraph 40. 90% of subcontractors in this industry are paid under deduction. Only 10% have the gross payment privilege. None of that, of course, excludes a discretion to cancel. Such discretion is plainly part of the scheme. The word may is used in section 66(1). But it does indicate that Parliament was very concerned, understandably given the problem being aimed at, to make detailed provision governing who had to be given the benefit, to keep that benefit tightly controlled, and to specify or enable the specification of detailed provisions governing removal.
Well, you'll have to help us, I think, after the adjournment as to what the nature of the discretion is. But we look forward to hearing you further at 2 o'clock.
I'm grateful.